You've heard the headlines, but the reality is heavier than most people realize. Since January, people who've lived for years are suddenly receiving expedited removal orders for missing documentation. If you aren't fully aware of these changes, one innocent mistake could lead to deportation. In this video, I'll walk you through 8 key 2025 policy shifts showing exactly how that could impact your case, your family, and your future, so you can act fast before it's too late. Hi, I'm Zyra Solano, immigration attorney with 15 years of experience across multiple administrations in immigration. The immigration landscape has shifted sharply in 2025. Since President Trump returned to office on January 20th, we've seen sweeping changes in policy and enforcement. Here's the truth, though. These are the most dramatic shifts in immigration in over a decade. Even attorneys who've been practicing longer than me, my colleagues, share how they've never seen the enforcement and policies that we are seeing today. The first change is nationwide expansion of expedited removal. As of January 21, 2025, DHS reinstated and expanded expedited removal to anywhere in the United States for immigrants who are unable to prove 2 years of continuous residence. This effectively eliminated previous geographic and duration limits. This means that you can now be deported almost immediately without seeing an immigration judge unless you pass a credible fear interview. And even if you've been living here quietly, missing a single utility bill or lease agreement could land you in removal proceedings. A second change is Executive Order 14159 and MPIP retooling. Executive Order 14159 broadens expedited removal, threatens sanctuary jurisdictions, and speeds up deportations. Migrant Protection Protocols, MPP, have also been fully reinstated under separate directives applying even to pending asylum applications. Even if your immigration case was paused under earlier Biden-era guidelines, they could now be required to return to Mexico and wait for hearings, potentially disrupting legal representation and family life. The third change is the elimination of enforcement priority guidelines. Executive Order 14159 revoked Biden-era prosecutorial discretion, leading to enforcement across all categories, including non-criminal unauthorized individuals. Your background no longer shields you. Whether you've lived quietly, raised U.S. citizen children, or have a crystal clean criminal record, you could still face ICE action. The fourth change is dramatic cuts to refugee admission. A parallel executive order significantly cut refugee admissions with tougher vetting and longer wait times. If your family member is overseas in the refugee pipeline, their case could now take years longer, even if it was accepted. Family reunification becomes a distant hope. The fifth change is stricter asylum credibility standards. There's no direct new case from the Board of Immigration Appeals in 2025, but matter of AB, a 2018 Board of Immigration Appeals case, remains in force, heightening credibility requirements, especially for domestic abuse, gang, or political fear claims. Asylum claims are facing tougher scrutiny. Cases that once seemed strong are now being denied, and legal preparation and corroborating evidence are more critical than ever before. The sixth change is aggressive interior campaigns. ICE has dramatically ramped up raids nationwide. Over 70% of detainees in June 2025 had no criminal history. Operation Safeguard executed simultaneous workplace and courthouse raids in so many major U.S. cities from January 23rd onward. This means that ICE is targeting not just undocumented immigrants with criminal history, but pretty much anyone who's deemed removable. No one is safe anymore, not even longtime residents. The seventh change is new crimes that trigger mandatory detention through the Lincoln-Riley Act. The Lincoln-Riley Act, signed on January 20th, 2025, mandates no bond and detention for undocumented individuals charged with theft, burglary, larceny, shoplifting, assaulting an officer, or other violent, serious bodily injury crimes. Even with a conviction, a single arrest for a minor offense like theft or a DUI could land you in detention and possibly deportation. The eighth change is work authorization delays. While specific policy changes are still pending, USCIS processing times have delayed work permits by months, and analysts warn of extended adjudication periods, possibly up to 365 days, especially for work permits tied to asylum. Even those legally eligible for work authorization may face serious waiting periods, creating gaps in income and eligibility and stress. These aren't theoretical threats. They're happening right now to real families, just like you. If you're currently in removal proceedings, deportation proceedings, awaiting asylum, or filing for some type of status adjustment, you must act immediately. Gather every proof of U.S. presence that you have: lease agreements, employment records, bank statements, school records, utility bills, anything that has your name, a date, and an address on it. Review any criminal encounters or citations with an immigration attorney. Even minor tickets could have serious consequences. Prepare for your credible fear or asylum cases with strong evidence, not just affidavits. And stay alert of ICE activity in communities around you and document anything. Keep records, notes, phone logs of enforcement actions of the things that you see in your community. The bottom line is that the margin for error in your immigration case has disappeared under Trump 2.0. No one is immune. Your stay depends on documentation, legal strategy, and quick action. Stay informed. Act now. In my next video, I'll explain which traffic-related citations can actually trigger deportation. Some are totally surprising and could be damaging if ignored. This is crucial information for anyone who drives or has a driving history in the United States.